and I will be your moderator today. I am the founder and CEO of Silicon Valley Sales Group, a Sandler sales performance company, enabling individuals, professional service providers, and businesses across a range of industries to achieve and exceed their revenue and growth goals. Our mission at Modern Ideas for Business is to enable business leaders to find opportunities and solve challenges presented by changes in the economic, political, and legal landscapes in which they compete. The other organizers of Modern Ideas for Business include Ed Correa, founder and president of Sagacent Technologies, a global leader in cybersecurity solutions. Paul Duran, a commercial banker for over 25 years and now an expert loan consultant, serving small businesses looking for the methods and means to fund their growth. And Jaco Grobelar, CEO of Broad Vision Marketing, developing and executing inbound marketing strategies that enable clients to consistently create more sales-ready prospects. We started Modern Ideas for Business with the goal of creating an interactive forum where business leaders can learn from experts in a variety of fields, ask questions, and share their thoughts and opinions on the topic of the day. So during today's webinar, feel free to raise your hand in Zoom to ask questions or offer your thoughts and opinions. We will also be monitoring chat if you want to ask questions there. So with that, I'm happy to introduce our speakers today. It's my pleasure to introduce Eileen Kennedy and Jamie Orendak, who are going to share their thoughts and insights on the California Labor Code Private Attorneys General Act, or PAGA, which authorizes aggrieved employees to file lawsuits to recover civil penalties on behalf of themselves, other employees, and the state of California for labor code violations. In other words, PAGA allows current and former employees to step into the shoes of the state to enforce California's labor code and recover substantial civil penalties, which could put your business in jeopardy, as such claims can present significant financial exposure. So Eileen is a labor and employment law attorney and partner at Bruggener Cohen. Her clients include closely held firms and large publicly traded companies across a range of industries. Eileen defends her clients, their executives and managers in employment class action suits, as well as PAGA cases involving the classification of workers, overtime pay, payment of wages, and meal and rest breaks, as well as single and multiple plaintiff unlawful harassment, discrimination, and retaliation cases. Jamie Orendak is the owner of My OHR, a seasoned HR professional with over 20 years of experience. As a true HR generalist, Jamie provides a wide variety of human resources services for companies as a cost-effective alternative to staffing a full-time human resources department. Jamie advises on all aspects of employment decisions, including personnel policy, employee relations, job enrichment, job evaluation, compensation analysis, staff planning, and compliance with federal and state regulations. So with that, I'm happy to turn it over to you, Eileen and Jamie, and look forward to a fascinating talk today.
Thank you so much, Dave. Appreciate it. Good morning, everyone. Jamie, I'm so happy to be here with you. I just want to add before I start the slides that a big part of what we're going to talk today about is PAGA and how to address PAGA in the new amendments. But we're going to start by highlighting a few of the new changes that are effective January 1 of 2025. So with that, we want to focus on a few new changes to the California leave laws that are effective this year. The first of which is qualifying acts of violence leave. Basically, what we've always had in California for a few years now is employers are required to give employees time off, unpaid time off, in order to address issues related to domestic violence, sexual assault, and stalking. What has happened in January of 2025 is that that law has now been expanded to include qualifying acts of violence, and the definition is here on the slide. It's any act, conduct, pattern of conduct that includes brandishing, exhibiting a firearm, like that kind of threat to bodily injury, death, or death to another, as well as a perceived or actual threat of or the use of force that might cause physical injury or death. So it's expanded, and what that means for employers is that they need um, to make sure that when employees have an issue related to this, that if they need to take time off for any of these reasons to appear in court, um, to, respond to an inquest or a jury trial, or to obtain a restraining order or some kind of injunctive relief. This applies to all employers across the board, and those employees are entitled to unpaid time off. You're allowed to ask those employees for some documentation related to that time off that they require. They should be giving reasonable notice if they can. And those are the items that every employer in California will have to abide by. Before I move into the next couple of slides, I want to ask Jamie, do you want to add a little bit more to that, or?
Yes, I do. So this new law will necessitate a change to your employee handbook. So you'll want to update your sick leave policies because employees can use their sick leave for this type of leave. Also, this applies to any violent acts sustained or experienced by a family member. So if their family member has some type of violent act and they have to care for their family member, they can take up to 10 days. They can use the sick leave, which is in California required up to 5 days. The other days can be unpaid. Also, we want to make sure that we evaluate the rights under California Family Rights Act leave and federal medical leave, if it applies in this case, because they could have rights under those programs as well.
Yeah.
All right, ready.
Fantastic. Yeah, so then Jamie started touching upon the family member so in addition, if you're a California employer and you have 25 or more employees, that's where the additional types of leave kick in. Some of them are capped, some of them are not. But yes, if you have a family member, that's going to impact those employers who have 25 or more. There are numerous types of support that an individual might get. So like Jamie mentioned, you might want to make sure that you are abiding by a California Family Rights Act leave or family medical leave, but there are other kinds of assistance. And there are certain things that can be capped. The first one that Jamie already covered, if the leave is requested to find housing, the cap can be limited to 5 days. Otherwise, it can be a fairly broad amount of time that you can give. Anything else you want to add, Jamie?
Yeah, that last note there is particularly important. This is a new law, so it's emerging. And of course, employees are going to find the boundaries of what this law means. So when your employee requests a leave of absence, it's incumbent upon us to get more information to determine if they might be eligible for any of the types of leave programs that are available. And there are many in California, so please consult with qualified counsel or call your HR representative so that you can get some additional guidance.
Yeah, it's becoming more and more complicated. Jamie, do you want to talk about the additional changes to paid sick leave?
To paid sick leave. So paid sick leave is up to 5 days, 40 hours for all California employers. You have an option of doing a grant method that is front loading the 40 hours into the employee sick leave bank, or you can operate on an accrual system, meaning you would accrue 1 hour for every 30 hours worked. When you use the accrual system, you'll continue to accumulate or accrual time up to 80 hours, although you can limit their use to just the 40 hours. That just means the extra 40 hours that you may not have permitted them to use rolls over into the new year. So it's essentially front loaded for the next year anyways. So employees can choose how they wish to use their sick leave, and it can include that crime victim leave, bereavement leave. It could include family bonding leave. And again, it's important that the employee has the right to choose how they use their sick leave. Unlike other programs, the employer can't designate sick leave for the employee if they don't choose to use it. Anything else I should mention about that, Eileen?
That is all fantastic. It's a great great recap of what needs to happen with sick leave. There are additional maybe not so much important for the folks in the Bay Area, but for employers in the Central Valley, this might be important to note that agricultural workers can use paid sick leave now when there's smoke, heat, flooding, or some environmental condition that forces them out of work. So keep that in mind that if an employee approaches you, an agricultural worker, and wants to use sick leave for that purpose, that's a new requirement, and you need to make sure that you're abiding by that new amendment. Other than that, nothing more on paid sick leave. This is also a new law. This comes up sometimes. Jamie just touched on this. There are some types of leave where employers can designate when employees must use paid leave. And there's a new limitation on that. So, for example, employers can still tell employees when they are permitted to use vacation time or paid time off, but they are now not permitted to do so in the 2-week waiting period before an employee receives paid family leave benefits through the state of California. I think this usually comes up in for example, a family medical leave policy or a California Family Rights Act policy or some combination of the two. In the past, employers had tried to designate some of that paid time off or vacation leave to run concurrently with family medical leave or California Family Rights Act leave. You need to review those policies and make sure that they're compliant with this new amendment. Anything else, Jamie, on this?
Yeah, and if I may add, this also necessitates a change to your employee handbook. Generally speaking, you probably have like a 9-page leave policy in your handbook. And somewhere in that policy, it says that employees are required to use 2 weeks of vacation before they take these particular types of wage replacement programs. So you need to make sure that there's a differentiation between paid family leave and the state disability plan, because they've carved out one little teeny part of those wage replacement programs that are available for employees. Also, as you help your employee to understand their rights for leave and for wage replacement, it's important that the employer understand which program they're going to be using. For example, an employee who is on a pregnancy leave would be using state disability for a period of her leave, and then she would move into the paid family leave portion if she decided to take her baby bonding under California Family Rights Act. So check your handbooks on this particular item so that the wording, all the syntax is correct, and that the employee understands that they have the option to use it and they're not required to.
Fantastic, fantastic.
Find this full webinar along with several others at modernideasforbusiness.com. You can register for upcoming webinars as well.